So thank you to everybody that has taken the time to attend this morning. It's going to be really informal. It's just a few highlights that we're going to deal with. Just a few, I think, something that we've all experienced over the last year. And I'm just going to share my screen.
Sorry, Kim, can I just say one or two things before we start?
Yes, sure.
Just everybody remember to switch on your chat function, because you can ask questions in your chat dialogue box as well. If you want to come live and ask your questions, so please switch on your chat functions and ask your questions there as well. Kim, and then just from my side also, thank you for organizing this. We know how much work this takes, and you are usually busy with that. And then to everybody present here today, guys, it's important to understand that when we do these type of things, the presenters are not experts. We're not here to do a lecture today. This is dialogue. We want to discuss this with all the participants so that we can get the information and share ideas and so on. Sorry, Kim.
No, agreed. Thank you. Actually, you're spot on there. You guys also see in your in the chat box there is a link for a WeTransfer. So what I've done is all the cases that we are dealing with today, I have compiled into one PDF document for you. There's a few extras in there as well. I'll go through it with you as we go through the slides. I've added in some let's call it some freebie stuff there. Some of the things that you'll see on the PowerPoint presentation will also be in those slides. So it is quite a big PDF doc. I think it's about 300 pages, if I'm not mistaken. But then at least you've got full judgments of everything that we're just highlighting today. Okay, so as I say, it's just a few highlights. I think if we had to do everything that's come out in the last year, we would probably sit like for a full day with massive books and not get through everything. So a few things I think that you guys are probably, and I have posted them, they are available, but they are in the PDF document as well, is with regards to the first cases as Magaga versus the Minister of Justice. And it was the failure by an employee to report an assault on an inmate, and there was a situation of insubordination. And the employee felt that his length of service should have played a big role. The fact that he had an unblemished record, that should have been taken into account with his dismissal. And in fact, the finding was at the end of the day that, no matter how clean your record is, as we know, there are certain transgressions and rules that doesn't allow for corrective measures as such. Then Marasi with Petrol SA. This was unfair discrimination. The employee claimed that they had discriminated against him based on the fact that he uses cannabis and as part of his culture. He's part of his traditional healer training. And when the court looked at it, they said, but there's no direct or indirect discrimination against the applicant based on his culture. In fact, the first thing that came to mind here, what the court said is obviously, as we know, it is to look at the safety. What sort of working environment? Petra SA, as we know, is huge. Once you in their premises, you are going to be tested randomly. You are going to ask to blow and to do all of those things. So they've got a substance abuse policy, and it sets cut-off limits for intoxicating substances like cannabis, where they had a threshold for cannabis, and Marasi tested positive. So their threshold was 50 mils, and he tested at 100. And then later on, he tested at 52, which was still exceeding the permissible limits. So Petra SA said, but they operate a high-risk facility. They require strict adherence to health and safety regulations, and that includes drug testing. So the employee was working in the refinery, and they're subject to random drug testing to ensure safety, as obviously this facility is also governed by the Mine Health and Safety Act and obviously occupational health and safety. He then claimed that he was unfairly suspended without pay after testing positive. However, Petro SA says that he was not suspended, but rather barred from entering the workplace as he was deemed unfit for duty. So he was allowed to take leave during this period. With regards to the traditional healer training, he'd informed him that he was undergoing training, which involved the use of cannabis. He requested accommodation for his cultural practices, including working from home during his training period. And I'm not too sure when you're working in the refinery, like I don't know exactly what he was doing, but I don't know whether he would have been in a position where he would be able to be working from home in the first instance. I just think it's, you know, when we look at reasonable accommodation and things like that, so we will allow you then to sit at home and work stoned. But yeah. He argued about the Prince judgment and the private use of cannabis, and they said, but Petro SA policy should be updated to reflect this. However, Petro SA maintained that the legality of cannabis did not change the risks associated with its workplace. And obviously the inherent requirement of the job, they said that the drug testing was reasonable and justifiable given the inherent risks of working in this environment. Testing negative for intoxicating substances, including cannabis, was deemed an inherent requirement of the job. The court found there was no unfair discrimination. His argument that their drug testing methods were outdated and did not account for cultural usage was also not supported by expert evidence. The court could not make a determination on the appropriateness of the testing methods without such evidence. So obviously they found that there was no unfair suspension, there was no unfair discrimination. They did not order costs because the court said that they do believe that he brought the matter to the court because he had a genuine belief in terms of his rights and his cultural practices. So I think if we haven't, you probably will at some stage be faced with something like this. And I think maybe it's good just to update with employees, you know, that in terms of cultural, traditional healing training and things like that, maybe have it as part of your policy that the guys actually must maybe disclose it, especially where you've got such stringent standards in terms of cannabis testing in the workplace. If there's any Q&As, I can't see that screen at the moment. I'm going to maybe ask Johan, maybe just to have a look if there is anything. Okay, I see he's already raised his hand.
Yeah, there's one here asked by you. I don't know. Oh, that's me. Yes, no, it says you here in the page. It's me. Yes, the question that I posted there was, you know, he mentioned their traditional healer training. Do we know from this case law whether that training was with a registered entity in terms of the new traditional healer group or forum or whatever?
I'm not sure. I just want to see here. They just say that he informed them that he was undergoing traditional healer training.
Yeah, to the other attendees here today, I wonder if it would have made a difference if it was a formal part of traditional healer training, if it was part of, you know, a formal training process.
Yeah, I still think that the employer's argument was still based on the fact that even if it was, I suppose you would have to make a choice, you know, do I want to do that or do I want to have this job? Because it's a requirement of theirs that obviously they're quite strict in terms of the limits. So, I mean, they allow for that threshold even. So they're not. It's not a situation of a zero tolerance where you must be not have anything. They actually give a bit of leeway here. And if they're saying that they weighted it because they say they first tested him and it was 100. I don't know how the reading was, but anyway, 100 mils, and later it went down to 52. So that probably indicates to me that he, more than likely, it is a possibility that he'd smoked recently, possibly, yeah. So yeah, so I think their biggest thing is that they're obviously working in a petrochemical environment, and that for them that is where the risk lies.
Tim, if I can also just come in here, I bought this book a couple of years ago. It's called Alcohol, Drugs and Employment, and it was the second edition through Juta, McCann, Burnhams, Albertine, and Bula, which is quite a nice book because it starts from dependency, the effects of alcohol on the individual. So just if anybody's interested, there's a book available with regards to that.
Okay, awesome. That'd be great. Yeah. I think probably Juta stocks it.
Juta. It is definitely, it's also branded as a Juta book from their library. Yes. Alcohol, Drugs and Employment. And it is McCann, Burnhams, Albertine and Bula, B-H-O-O-L-A, Bula.
Just to come back to your question, I've got another document here, just with traditional healers. There's apparently new regulations that are going to reshape the medical, or this more so with the medical certificates, which we'll get to just now. But they are talking of proposed new regulations for the traditional healer health practitioners. Be interesting. Yeah, I can't see that cannabis is part of, I suppose, depends what traditional healer you are, whether you're going to be using substances like that. Because I talk about herbalists as well. So they've got mandatory registration, minimum training periods, and then there's admin requirements. So yeah, it'd be interesting once that's out that we obviously get a copy of that we can just get ourselves acquainted with what's in there.
Well, I think we've got a very good publisher on our groups that will publish that the moment it's out. So
okay. Do you know her personally?
We know somebody that knows something, you know.
That doesn't get that doesn't think sleep's important. Yeah. Let me just go to my next page here. There we go. Okay, so this one here I thought was actually quite an important one as well with regards to the denial of legal representation at arbitration. And the commissioner conducted the inquiry incorrectly by his failure to take into account an essential step of the inquiry. And the court said that they found that the commissioner reached an unreasonable result by refusing the applicant legal representation. So I think that one was just a nice to have, you know, when we are faced with those situations where there is an application for legal representation, that we just bear in mind. So the applicant was employed by the first respondent, which is Transnet, as a supervisor, and he was dismissed for misconduct in 2018. He challenged the unfair dismissal at the bargaining council, and when the resolution of the dispute was being processed at the bargaining council, the applicant applied for legal representation at the planned arbitration. This was obviously opposed by the employer, and the commissioner found that the application papers issued a ruling refusing the applicant legal representation, and he was then subsequently represented by 2 co-employees, while the respondent was represented by its employment relations manager. They said that they obviously found the applicant's dismissal fair, but then the applicant subsequently filed the application at hand seeking an order reviewing and setting aside the ruling and the legal representation and the arbitration award. So they said that they found that there is, in terms of the rules, for the bargaining council, it prescribes how the inquiry into whether a party should be granted legal representation should be conducted. And they felt that the commissioner incorrectly, through conducting the inquiry the way that they did, they failed to take into account this essential step of the inquiry. And by doing so, misconceived the dispute before them. This resulted in reaching the unreasonable result of refusing legal representation. Whether it's going to change, it'll be interesting to see whether it changes the outcome of the fairness of the dismissal at the end of the day. And as much as, yes, they've got the right, you know, a lot of commissioners in the instances, I'm sure you guys would know, in the instances where the applicant's not represented, there's also a duty on the commissioner to assist. So, yeah, but be that as it may, like I said, it'll be interesting to see whether there's a different outcome if he goes a second round on this, whether it changes the actual fairness of his dismissal or not, because then it's almost a bit of a waste of time, in my opinion. Nothing in the chat box, Jan?
Nothing in the chat box.
Okay.
When we prepared, Kim, because I was privy to these topics beforehand, I just picked up a trend, and I think everybody here can maybe also have an input. Was I recently had very good or success with opposing legal representation, and for some even where I was surprised that it was not allowed. And then on past Thursday, I had a case which I thought there was no way that legal representation was going to be allowed. A senior manager who is well educated, she's in fact the 2IC of a division in the company, and the commissioner came with an unusual ruling. There are some questions of law which the applicant may not be able to deal with in terms of comparative ability. So she combines the two, to say instead of just comparative ability, she says, but these questions, I'm telling you, I did not understand it. Very interesting then, but I think there was something off with the commission as well. Because then I said, well, that, if that is, and she says in her ruling, because I know you, I believe that, there's even the attorney might not be comparative enough compared to you, So, okay, well, thank you for the compliment, but no thanks for the ruling, I then said, well, I didn't understand that. No, shush. I didn't. Sorry, my phone answered. So I said to her, well, I believe it's now our right, the respondent's right, to consider whether they want legal representation or not. It's just the right. And she says, no, you must apply formally for a postponement, which I'm not going to grant because you should be prepared. Said, how can we be prepared?
How can you be prepared? So you must have an attorney sitting there on standby. That doesn't make sense.
He said, yes. But let's go down to the senior commissioner. So we go down to the senior commissioner, and there wasn't even a discussion. The senior commissioner just said straight away, yes, of course, you're right. So it's just something that I've picked up. Was it that particular commissioner, or is there now, we don't know about these practice notes or that from senior commissioners, but has something been released to say, be careful, don't just, go ahead and disallow legal representation? And I just want to put that out there to everybody to say that was my experience the past week.
Yeah, and and the thing you have to be prepared for every scenario when landing up at the CCMA, because you never know what these applicants bring with or come with or surprise us with.
Yeah.
Okay, so one of the bigger discussions, I think that possibly that there's a few of them that I'm going to highlight, because you'll see, I wouldn't say inconsistency, but depending which side of the table you're sitting is going to depend on which argument you're going to take here in terms of all these medical certificates and things like that. So this is obviously the case, I think, that really rocked the boat a lot, was the matter with Woolworths and the situation where the employee was allegedly submitting forged medical certificates. Woolworths had questioned the legitimacy of two of them. One was in 2016, the other 2018, after receiving warnings about suspicious certificates linked to the doctor. So apparently this doctor was already under investigation, from what I understand. And it seems, I don't know if it was him or somebody in his rooms, but he was definitely under investigation for these certificates at that point, at a stage. So they discovered that the two medical certificates. So as a result, they did an investigation. And the employer said, well, according to them, they had a suspicion that he was selling medical certificates. And this obviously resulted in the employee being charged with misconduct, in being a breach of company policies and procedures, submitting irregular medical certificate to justify her absence. In addition, they said that she'd been dishonest. She was found guilty, and she was obviously dismissed. The matter went to the CCMA, and the commissioner incorrectly identified the key aspect before him as to whether or not the medical certificate submitted was irregular. He found there was no evidence to show that the employee was not sick in 2016 and in 2018 during the days on which she submitted medical certificates. He concluded that the medical certificates were valid and regular, having been issued by a qualified and registered medical practitioner. I'm not too sure. I'm sure we've all seen doctor's notes. I've had cases where the notes have come from the doctor's room itself, and then it's somebody working at the doctor that is selling the notes on the sly. So I don't know on what basis the commissioner made that assumption to say, well, it is a issued by a registered and qualified registered medical practitioner. Yes, it might have been his notepads, but who's to say that it was actually the doctor that issued it? So that basis, they found the employee's dismissal was substantively unfair, and that's obviously when the Woolworths went to the Labour Court and took the matter on review. The Labour Court concluded that the Commissioner's decision was reasonable and justified by the evidence placed before him. And the employer's gripe with the arbitration award, and therefore the finding of the Labour Court, was kept in very clear terms in the employer's heads of argument. And there were witnesses that the employer called, and the witnesses gave evidence of untoward happenings at the medical practice. So there was a lot to suggest that I don't think that the employer acted unreasonably on the suspicions that they had. I mean, they had witnesses that came in and said, well, we know this, doctor, this is what's happening. See, there's a second part. No, it's not a second part. So they felt that there was evidence that was given that was hearsay evidence, but it was corroborated by other evidence, and that the doctor had obviously signed off on the letter. So what would happen is that people would go to the doctor's consulting rooms and would be let out in less than a minute with a medical certificate. So there was no privacy, and so they were able to observe what was happening inside the consultation room. And based on what they observed, they concluded that Dr. Frempong might not be a real doctor, and they suspected he was selling fake medical certificates. So I'm not too sure why they didn't go and check. I mean, there is on the website with the Health Professional Council, there's two websites that I use where you can actually go and verify the practice number and the doctor's practice number. So I think maybe there they fell a bit foul by not checking out if the doctor was really a registered doctor at the end of the day. So the commission ruled that there was no evidence to support that the employee was not sick. He also found that the documentary evidence of Dr. Frempong's qualifications and extensive experience as a doctor, there was obviously evidence to support that, and he was registered. So then it was established. The South African Medical and Dental Council had also issued, had a certificate issued by the Health Science Academy. So none of this evidence was put into question. And they said, well, they're finding it difficult to understand why the employer is saying that the employee is obviously guilty of the transgression. So when it comes to obviously the takeaway lessons here in terms of medical certificates and calling it into question, the first thing we need to obviously realize is that medical certificates are not conclusive proof of illness. The employee has an evidentiary burden, and where the admissibility of a medical certificate is disputed, the employee must adduce evidence of the doctor, and where the doctor is called to testify, then obviously if the doctor can support the certificate and confirm it and justify who he is, then the employer would have difficulty in saying, well, there has been some sort of dishonesty or misconduct that has taken place. In fact, the doctor even came to testify with regards to the, he said that the employee had come to his rooms. He decided to give her 4 days sick leave based on the condition at the time, and he denied studying any sick notes. Wilbur said, well, according to them, the premises did not look like a doctor's surgery, and because of various suspicious aspects. Out of the judgment, they also said, surely it cannot be that a doctor who is otherwise a qualified doctor who dabbles into some or other illegal activity of selling medical certificates is somehow assumed to be disqualified from examining people and book them off sick, untainted by the issue of illegally selling medical certificates. The idea that an employee who happens to go to a doctor who is not trusted by an employer must be subjected to a disciplinary process for using that doctor is troubling. So that was pretty much the key takeaway that obviously came from all of this. Okay, any questions, any input?
No, I just wanted to mention that Ivan posted in the chat box the link to verify practice numbers and so on.
Okay, great, thank you.
Yeah, it is there for everybody just to have a look at. Remember also these sessions are recorded, so if you can't get it now, you will be able from the recording to get it. He did post a link there. Kim, I've got one question, and it's once again open to everybody. I wonder if your medical certificate policy, if you include in that policy that it is the responsibility of the employee to ensure that it is a legal certificate, a legal doctor, etc. I wonder, I'm not saying that's a fail-safe, but at least that will count in our favor when we lead evidence like that at the CCMA.
Yeah, I've actually just recently updated for my clients there's sick leave stuff to also deal with medical certificates, and obviously the virtual consultations and all of that. And I know somebody posted something about it on the group, and there was a reference to the 2 days, and I couldn't quite establish where it had come from, but I've subsequently found actually where it was contained in. So just that you guys are aware. So where is it now? A professional nurse that is allowed to obviously diagnose and treat may only book an employee off for a maximum of, here we go. So SANC recommends that a professional nurse practitioner should only issue a medical certificate for a period not exceeding a maximum of 2 days. So I've actually incorporated that into my policy in the event that employees are going to go that route, that they're aware of the fact that we are only going to work on those 2 days. Because they're saying if the patient's condition is not improved, the patient should be referred to a medical practitioner or to the next level of care. Any other nurse or professional nurse who does not possess the additional qualifications are not entitled or certified to issue and sign medical certificates.
In the clause we've included in our medical certificates policy says it is the responsibility of the employee to verify the authenticity of the certificate and the credentials of the doctor. Just short and there's a question from Fritz, it looks like. Fritz, we can hardly hear you. You might have a problem with your connection or your mic. You are welcome to type your question then in the chat box on the right-hand side of your screen if you've activated that. Try again, Fritz. No, Fritz, you'll have to type. We can hardly hear you. Please type your question in the chat box. And you can activate it by clicking at the bottom of the screen or using Alt and H at the same time, your Alt key and H. Thank you. Kim, let's move on.
Okay.
Yeah.
Right, so...
sorry, there's a suggestion here from Rudolph. Let's just see. It may not always be possible to do, but maybe employers can determine from employees to place on record their medical professional they normally use when they do
Mm.
this professional, it already raises some red flags. Rudolph, yes, I like that, because even in the security industry, there are some doctors who are contracted to that medical insurance that they have. Yeah, so I think specifically in some instances, any other ideas on that? I think you may even include this on your application form. Who's your medical practitioner? Because then there's no suspicion on why you are asking them.
Yeah, especially we ask for like next of kin and stuff like
Right.
that. So in case of an emergency, yeah, who's your preferred, yeah, then there is no suspicion, because employees always think that there is sometimes there is, but there's a hidden agenda.
Yeah. Right.
Okay, so with regards to the Transnet ports and this next matter, the employee was dismissed for submitting fraudulent sick notes November and December. These medical certificates were found to be invalid and fraudulent after there was an investigation. Here they spoke a lot about the handling of hearsay evidence, and there was no proof of fraudulent intent on the and to show whether there's proof of fraudulent intent on the employee's part. And you'll see just now we're actually going to discuss in quite a bit of detail with regards to actually hearsay evidence. What is it? How should we be dealing with it? What are we looking for? And so forth. So I just want to just get this case here quickly. I just want to see if there's anything additional I want to add in here for you guys. Okay, so this employee was awarded reinstatement retrospective to the date of her dismissal after finding her dismissal due to substantially and procedurally unfair. So obviously Transnet took it on review and set the award aside, seeking alternative orders if the review was granted. Obviously, the employee opposed the application. The applicant challenged the third respondent's handling of hearsay evidence attributed to Dr. Umar. They concluded that there was no proof of fraudulent intent on the employee's part, which was necessary for the alleged offence. So they found that the applicant failed to establish the guilt and dismissed the application. So despite the dismissal, the respondent was awarded costs due to being deprived of an income and bearing the cost of litigation. So yes, again, it comes to, we look at Woolworths, and Woolworths says it's up to the employee to obviously bring the evidence and prove it. Here we sit with a situation where they're saying, well, that it was just based on hearsay evidence. So I think maybe there should have been a burden placed back onto the employee to prove that it was not fraudulent. But it was found in both instances that there was no proof that there was a fraudulent intent on the employee's part. I've had situations where the guys have thought that they are actually consulting I had a guy that went to go and see the doctor, and then the doctor had left the province, and then he went and was told to go to the Sun, but the Sun was not a qualified traditional healer, and got a letter there, and he was under the impression that it would be okay. But at the end of the day, one has to look at a bit of common sense here, is that somebody that's not qualified and registered cannot be issuing you with documentation in support of an illness from work.
I think it's not just common sense, because the next case they said the commissioner found that the employee should have noticed the discrepancies and so on. So also a duty placed on the employees,
Yeah. So that's why I've highlighted a little bit of everything, because everybody's quick to say, yeah, okay, so now we must now say yes, Woolworths is now the one to all and be all of determining things going forward. But you never know what the next commissioner comes out and deals with and says and finds. So there's another matter with regards to let me just find it here. I don't know if I've got it on here, but there's a Sibanye Rustenburg one as well, with false sick notes. also, with regards to the Commission found the employer had committed serious misconduct, but could not be faulted for focusing his inquiry on this limited issue. They said that the employee had submitted fraudulent sick notes and as a result received pay for days that they did not work. They were purportedly issued by Platinum Health, but stamped at the RPM hospital. So the investigation revealed the employee did not visit the Platinum Health as recorded in the medical certificates. So yeah, so sometimes, you know, and that's, I find a lot of times the problem with the employers. They say, oh, okay, yes, we've now got a fraudulent medical certificate, but don't want to spend the extra day or two because now they full on intent on getting rid of somebody, to spend an extra day or two to actually investigate the thing properly, to see how much merit is there in this. Get statements from the employee, get hold of the doctor's practice, email the note to the doctor's rooms, ask for confirmation. You're entitled to the confirmation. So yeah, sometimes also having to rein in a little bit with the employers, that they also realize that it's not just a quick thing of, yes, let's go ahead and do this because we believe that it is what it is.
There's a question from Razan on requirement to call a doctor to an arbitration if doctor has sent formal letter indicating the letter is and the message is cut off. But I think Razan is just inquiring, should a doctor be called to arbitration as a witness? I think, Kim, if I'm correct, under hearsay evidence, we will deal with that later on in the presentation.
Yes, yeah.
We will deal with it. There's a whole section on hearsay evidence and the requirement to call a doctor or not.
Okay.
Nothing further, Kim?
Okay, then back to the issues of breathalyzers and alcohol, and you'll see as we go through this one, there's been a few changes as well. What I can say is the employers using the groen liggie, rooi liggie breathalyzers, it's probably better to try and get them to invest in proper breathalyzers that give actual readings. I think it is definitely a better route to go than just the red light and the green light. But that's just my opinion. So this employee was employed as a storeman. He tested positive for alcohol in 2 successive breathalyzer tests. So as with the policy that we've got, we make sure the employees get tested. If there is a first positive, we get the employee to wait 15 or 20 minutes as part of the policy. They blow a second time. Plus, we've got that whole observation checklist that we go through as well. So the employee admitted that the test had registered positive, but he felt that he should have received a final written warning as he was not working in the manufacturing plant. So the important takeaway from this was proving that employee is incapable of performing their duties. And this is the trend you'll now see coming through more and more and more and more, even when we deal with the Innova case with Barlow World, same situation. Can the employer show that the employee is incapable of performing their duties? What duties does he do? Is he an admin person? Is it a receptionist? Is it a working at Height Sky? Is it a forklift driver? Is it a professional driver? Is it somebody in healthcare dealing with medication and ill people? All of those things. So all of those things have to be obviously taken into account. So they came back, the finding was that the employer had failed to show that the employee was incapable of performing duties. They said the commission noted that according to the authorities, it does not follow that an employee who reports to work with alcohol in his bloodstream must be dismissed. Each case depends on its own merits. The applicant had 2 years of service, had received no warnings. The applicant's claim that he'd been denied permission to consult his doctor was baseless, as he had not done so after being turned away from the premises. However, there was no evidence to show the applicant was unable to perform his duties. So he was reinstated, but without back pay. So yeah, he was a warehouse assistant. Let's see what his readings were. They displayed at 7:30 in the morning, it was 0.09. And at 7:55, he gave a reading again of 0.07. So the respondent said, yeah, but he's in charge of logistics to ensure customers' things are delivered on time. He manages the dispensing team, and the applicant reports directly to this witness. And situations like this, and I've got it with a few clients where my clients' employees may not enter the client's premise, the customer's premises, without first undergoing a breathalyzer. So it's all good and well to say, yes, can he or can't he perform his duties? But now we sit with a situation where that customer's got policies that might not be aligned, and actually they don't care. They just say outright, we don't want this person back on our premises. So now you sit with a situation. You either have to find somebody that you lucky, if you can rotate, great, but if not, it's a problem. So it is, I think, possibly a good idea if your client has got an HR manager, and especially in situations like that where you've got guys working on customer sites and going into premises where they would be required to be breathalyzed randomly or every day, is possibly ask the customer for a copy of their policies as well, that we can make, that you make the staff aware of what the rules are at going into the customer's premises as well. Because now, obviously, now the employer sits with the problem of what do we do with this person that's not allowed back onto the client's premises. So they had and I know Christy raised this in the chat the one day as well, and I know it's become a thing about having this zero tolerance wording, and I can understand why it's the reasoning behind it. Obviously, zero tolerance is not going to apply to every single employee based on their position and the capabilities of being able to perform. But in this instance, the company had a policy that said you have to test zero. Anything above is in contravention, and they'd stopped using breathalyzers during COVID and started again in, let me just see, 2023. So it was reintroduced again. So everybody who attended a meeting was filled the attendance register, and they were told, listen, we're doing breathalyzers, and obviously everybody was tested. So yeah, so it again comes back down to, I think, the observations. They brought in their health and safety guy to give evidence about the environment that they work in, and that there's a zero tolerance policy, an impairment of ability to perform work properly. And they, in fact, they actually talk about it. So obviously the employee is saying, well, according to him, he feels that he should have been given that opportunity, because obviously the employer hadn't shown that he was not able to perform his duties. Out of interstate, yes, it was a Monday morning actually, so we know how weekends go. It wasn't a month end, because generally I found on month ends it's actually even worse. So yes, so this one is also included in the bundle that you guys would have able to download. But they do talk about whether dismissal was appropriate or not. They refer to the tanker services case as well, where they actually took an extract from that, where it says, the court says, employee guilty of being under the influence of alcohol when not able to perform tasks entrusted to him with the skill expected of a sober person. So maybe that's a nice way to word your charge, to say that we believe that you're under the influence because you do not have the skill expected of a sober person to perform your duties. But obviously up to the employer to know, once again, show that. But that's where your that other checklist comes in, your observation checklist. I think quite a lot of weight is attached to those in terms of evidence when when arguing these cases at the CCMA. Okay, any questions, any input, any?
Yeah, we do have one from Rudolph that says regarding policy, proving employee capability. Employees should take time to define in their policies when it is deemed, in inverted commas, proven that an employee is incapable. This will then help in proceedings. Rudolph, do we understand it correctly that you should include something like doing a sobriety test or something like that? Just maybe if you want to comment on that, please.
Johan, thank you very much. Yeah, I think depending on the sector and environment of the employer, the employer should take time and set when is it deemed that an employee is actually incapable to do his environment. Take time to set policies. So when it comes to drugs and alcohol, whatever test you use, clearly define that if this is what happens or is found in the employee, then it's deemed proven. Deemed proven. So at a later stage, when it comes to actually prove the matter, then at arbitration, you've got a document that says when this environment, this situation occurs, it's deemed proven that the employee is incapable of performing his duty. Then you don't have to prove it at a later stage. Your policy proves it itself. I hope that makes sense.
Yeah, thank you. I also just want to draw everybody's attention to the articles on SA United Employers on the portal there. Colleagues, there's a very, very, very good article written there. And of course, this is also the value of being an official from such an organization. And there, it clearly identifies the real test, and it gives you 4 categories. Visual indicators, in other words, red eyes, poor balance, stumbling. Olfactory indicators, smells of alcohol, etc. Auditory indicators, slurred speech. And in the conduct of the employee, sleeping, aggressive behavior. So do yourself a favor, please go and read that article on the portal. It is available there. Dirk, you are also talking of the Romberg test. Do I have the right terminology there?
Just repeat your question.
You were also talking of the Romberg test. Am I correct? Dirk, I think we've got a problem there with your connection. Guys, in any case, from Dirk also, I think it was, Kim, can you recall, was it the Romberg test from Dirk referred to on the group?
Might have been.
Test for drunken. I couldn't hear.
Sorry,
I couldn't hear you.
Dirk, your connection is very bad. What test do you use?
I know that my connection is very bad, very poor. I have a difficulty in following everything. So I don't know what I can further. I tried what I could.
Yeah, no, thanks, Dirk, no problem. Guys, I also was told by Elise that my mic is very soft. Can you all hear me? And Kim, can you guys?
I can hear you, yeah. I'm fine.
Thank you. All right. I think that no further questions there, Kim.
Yeah, maybe just another idea or thought, with occupational health and safety, the employer is obviously required to sort of highlight working areas and risks and all of that, and even maybe contain in there, incorporate the safety and the drugs and the alcohol into that document as well, because that's also then quite a nice working document and to have something to refer back to. if you guys, I know that there was quite a nice one that went around for COVID. I did one the other day for a client of mine in retail. But it is obviously a nice document to say, okay, so this is the area, or this is the position, or this is whatever. These are the risks associated with it, you know, like slip and trip incidences. So one can possibly build in the safety thing with regards to various areas and positions and high risk safety and so forth. So it might also be a good idea that we sort of not just in a policy, but have it in your health and safety stuff as well.
I'm wondering also, you know, in terms of, let's say, restaurants where waiters are serving the public, and, you know, smell of alcohol could be very bad in a situation like that. But I don't think then it falls under this category of intoxication. So, you know, maybe then what we should do is define this in another category in your disciplinary code or your policies, and not confuse the two issues.
Yeah. I mean, it could even be a situation where you're actually bringing, especially let's say somebody complains about it, let's say on a feedback page or a Google review or something like that. You know, so one has that reputational damage as well. So that is possibly a different route to take. Again, in terms of saying, well, you know, the smelling of the alcohol it can be problematic. But the problem is, so because the smell of alcohol doesn't necessarily mean that I'm intoxicated. We all know that. So we would have to find something else to categorize it under, and it could be a situation of, I know I was at the Woolies the other day, and the girlie behind the till, jy ruik mos wanneer dit wit alcohol is. It is maar net the vodkas and the whatever. So it's funny. I'm very sensitive to the smell, so I pick it up immediately. You don't want to really say anything, but yeah, it sort of makes you wonder. And then again, it comes back down to now. Then they say, okay, well, the employer should possibly look at having an employee assistance policy in place. And I'm thinking, yeah, okay, but again, I know that's probably the softer side of things. And is to say, well, how can we help you? But you're sitting with an employer that's not the first one to come forward and put up their hand and say, I admit I need help, and wait till we get into a situation like this. Yeah, it's you know, where does one offer that assistance, and to what degree? I suppose as an alternative to dismissal, one could put a ruling in place or a finding in place. The employer has to attend like a AA and show that they are attending and subject to random testing and all of that. And then possibly if they found to be under the influence again, look at a breach of that undertaking. So it's but these employee assistance policies, they're nice to have, but I think it also it becomes very onerous for the employer as well too.
Kim, there's a question here from Razan. Kim, why would you suggest the testing mechanisms with a reading? Even the alpha testers, which costs companies 8,000 Rand, is red and green, but when you look at the parameters, it shows green is saying anything under 0.03%. So she's saying that those lights also indicate certain levels, that you are between this and this and this and this. Yeah.
Okay, I'm just aware of the ones where you either get a red or a green, and it's not giving you an actual read. I know it will only give you that, but remember we have the false positives as well. So with those, the employee can say, yeah, but you know, I ate this and I drank that and I did this and I did that. What's nice with the ones with the readings, if the guy's going to come and say, and I've had it a few times where the guy says, oh no, you know, I've got such a bad cold and I went and I bought cough medicine and I had some cough medicine. But then when you go and you do a bit of research on it and you look how much cough medicine he would have had to have consumed to get the reading that we got on one that actually gives an actual reading. I know some of them got quite fancy. They even give a printout, and they there are a few that are not that expensive, and they actually work off a app as well that's linked to your. There's an app that you download, so the employer's always got record of the breathalyzers that are done. But having that reading, I think, just sort of strengthens it. But some employers go to the extent of saying, well, from here we then take you for a blood test. That's the next step. So, but again, if it's to prove the point of employees saying I'm not intoxicated, it's not alcohol. This is why I'm blowing. Yeah. Let's also make sure that they're calibrated like they should be every year. That's very, very important.
I think, Kim, that book that I was referring to also earlier, that also explains it quite a bit on how much you have to consume in order to get to that reading and so on. So yeah, a good book to have.
Yeah, you'll see actually in the bundle that you guys got, and it will actually come up just now. I've actually shared an article that was written from one of the attorney guys with regards to the breathalyzers and you know how good are they, how you know what in terms of evidence is it sufficient enough. So there's actually an article that I have included as well that also I just think needs to be more educated than the next guy that's going to come in and argue that this was this was not the right, you know, that the reading was wrong, that it was skewed, that it couldn't have been like that because of A, B, and C. We know, remember the whole story about the hot cross buns and all of that. So you will have those instances where he goes, oh, but I went outside quickly here to the little spuzzer outside the company's premises, and they're making things that contain yeast. And so, yeah, I mean, there was a whole testing done around that as well.
I think that article is still coming later on in the presentation.
Yes, yeah, that's right, yeah.
Thank you.
Okay, so this is quite a nice one. I think it's about time that it happened with regards to trade unions and them being able to represent employees outside the scope of their that is defined by their constitution. Because yeah, it is been happening for far too long. It's been allowed for far too long. And the court has actually now come and said, you know what, I mean, this is a constitutional court ruling. So as high as this, further than this, that's the highest that we can go in terms of a ruling. And so I think this holds a lot of water and a lot of strength, that they're saying that unions can only represent their members in labor court proceedings in terms of section 161C. The dismissed employees were not valid members under NUMSA's constitution. The union lacked legal standing to represent them. So they found obviously that the participation and representation on behalf of these employees was unlawful. And they referred to the lawful packaging, which I've also got on here, with regards to trade unions cannot admit members beyond the industries listed in their constitution, nor act outside their constitutional powers. Requires that unions can only represent their members in labor court proceedings. That since the dismissed employees were not valid members, they said that, sorry, this is actually a repeat of the previous slide. So yeah, so that's what that one basically came down to. But lawful packaging was the same thing with regards to NUMSA again, that same situation, that they sought to claim rights to access the workplace and the ability to represent workers. And they were saying, but you do not cater for our industry or sector. It's not in your constitution. So again, we have that confirmation again. I know Jan asked the question the other day with regards to the bargaining councils that are allowing trade unions to be party to the councils, where whether or not their constitutions, and it was actually out of in terms of the restaurant industries, and I think it was also NUMSA.
NUMSA, exactly, yeah.
On what basis are they then given, you know, that the bargaining council should also be making the same determination? And maybe it was never done before, and if it wasn't, but maybe it's time that, yeah, that it then should be tackled, because they've actually lost nothing in an industry or a sector that does not cover them in terms of their scope.
Yes, just to add on to that, I think colleagues, just take note of this, that the NUMSA is party to the agreement in the restaurant and catering industry, to the main agreement there. Now, this judgment clearly says not only representation, but also in terms of collective bargaining. So that means that they could not have been party to the signing of that agreement, and therefore we can always challenge this when you're sitting in front of a commissioner there to say that, but this main agreement is not applicable to our members because of it's not legal. I'm just, mentioning this. I don't know how far you will get with that argument, but here's an argument for you to use when you're trying to get out of the bargaining council and into the CCMA. Remember also, just when they published the new rates, and it has not been extended to non-parties yet. But while they publish those rates, the new rates, it specifically excludes members of SA United Employers Organization, NIASA, etc. It was, sorry, am I talking about the metal industries here? Am I right? It was the metal industry.
Yeah.
Yes, where we are not a party to that. So what I'm saying is you must always just check on whether the organizational rights of a trade union is in order, their constitution and so on. Because here's two examples where the MEIBC realized that and they said not applicable to SAUEO members. And here's another one now through this recent judgment where NUMSA could not have signed that or because they are not a party in terms of their constitution.
And actually, when you look at NUMSA's argument here, they say the union says that it should have the flexibility to admit members from any sector, emphasizing freedom of association. But the court says, but you should be complying with your own constitutional criteria. You cannot adjust and adapt it as you deem fit. And that's the same then as the employer saying, well, we also have the right to freedom of association. I should also be given the flexibility. Now, I don't want to belong to the council anymore, so that sort of argument is this is their thinking. And yeah, the court just said, well, it doesn't work like that. You need to stick to the rules.
Yeah. I've recently had NUMSA approaching one of my members in the food industry. When I pointed it out to them, no, we're aware of that, but we're just asking kindly to recognize it and so on. So yeah, they're coming with all of these tricks and stuff to try and get recognition.
Okay, so hopefully we won't be done by the time Dirk is going to log in. So let's see here. Heuben submitted quite an interesting case. I had a chat to him yesterday, and we were hoping that the commissioner involved with this was actually going to be part of to come and give a bit of a background to the case and come and chat about it. But unfortunately, at 0.99 yesterday afternoon, the commissioner felt that it might not be a good thing. Thought there might be a bit of conflict of interest, possibly. Yeah, but very interesting. So he was saying that this was the day that the president announced the lockdown, and the employees at the client heard that other companies in the area or around them were paying the staff the 3 weeks in advance, because at that stage, remember, we were only going to be shut down for 3 weeks. And they were unhappy about the fact that their employer was not going to do the same, and they actually took the owners and other employees hostage. And this led, obviously, they were dismissed for threatening the well-being and safety of the directors. And the arbitrator found the dismissals to be substantively and procedurally fair. However, the Labour Court reviews and sets aside the decision based on Marley Pipes' judgment by the Constitutional Court. The Labour Court took a misstep as the Marley Pipes judgment was not applicable to the specific charges against the employees, and the Labour Appeal Court set aside the Labour Court's order. I've actually given you both of these judgments in the bundle. You'll see that they are both there. And he was saying that, and this, funny, we had a discussion yesterday about saying, you know, it's very easy to sit as a commissioner or a judge or an adjudicator where he says, now, you know, this is now, let's say 4 years later, and you cannot bring the emotion and the stress and the fear that happened on the day and actually let the judge or the commissioner actually experience that situation. We're now sitting 4 years later in an air-conditioned room where somebody's going to make a decision on something that happened. And yeah, I have the same issue. You know, it's like the commissioners they're not on the ground with the employers, realizing what they have to face in the day-to-day challenges, especially the small guys. You know, you've got a little company. We're all fighting for a space under the sun, just to be able to make a living and to pay salaries and keep people employed. Things like this happen, and then you have a decision that comes out that you feel, but you know what, you were not there to experience this, to realize what was actually going on. And he was saying that it was hectic. Hubin was actually there on the day as well. He said that they had the police there, the cops came in to try and defuse the situation. They said that they had a situation where they had to try and identify who the employees were. And the arbitration decision was based on evidence that employees were directly identified as participating in the misconduct through photographs and videos. And this also dealt with derivative misconduct, and the common purpose was misplaced. So this is where the Marley Pipes judgment also came in. But it actually makes for some interesting reading. Like I said, both judgments are there for you to have a look at. And also quite nice just in terms of also dealing with the derivative misconduct situation, because those ones are can be a little bit iffy sometimes, where you've got more than one employee in a situation. Yeah, it's actually a pity that he's not able to have given us a bit of input on the situation, but definitely I think this one really stood out for him at the end of the day, with the fight that they'd gone through to actually try and get it ruled in their favor. Has Rourke logged in? Is Rourke here?
No, he's not in, Kim.
Oh, okay. All right. He submitted one just with regards to okay. Do you guys want to have a comfort break? I have to look for myself, hey. That's extra.
Guys, I think it's nearly 20 past, so you may lower your hands. Everybody will be available in due course. Thank you.
Yeah. Maybe just before we get to although it is on the slides, I see there was a question there in the box with regards to Ivan asked with regards to to the blood testing and the refusals and the things like that. So, I don't know if I've got, let me just see if I could just share. I'm not sure if it's part of my slides. Let me just have a look quickly.
Now, Tim, I did respond while you're looking for that. I just also responded to them in the meanwhile to say, remember, it is also the duty placed on the employee to dispute those readings now. So if it was him that went for the test, obviously he will produce it as evidence. If it is the company requesting it and he refuses, I think, it's the same as a refusing to do a polygraph. The negative inference you may draw from that to say,
Exactly.
take the test. Yes.
Yes, yeah. Because there was a case now with Pioneer Foods where the employee was already under a final warning for evading an alcohol test. So the employer has got an alcohol policy whereby every employee entering the company premises must be subjected to a mandatory breathalyzer test each time without exception. So he reported to work, but he did not enter through the main gate, but rather via the dispatch gate. So which probably tells you already that there's a problem. Because the employer only had one breathalyzer device, which was located at the main gate, and there was none at the dispatch gate. This came to the attention of the shop stewards, and the employee was breathalyzed. Because obviously the shop stewards don't like him, so somebody went to go rat him out because he was employed as the depot manager. So they went to go and complain. Obviously, he was breathalyzed, and the test came out at 0.085. Then the second test which was done 20 minutes later, also reflected a positive result, and he was sent home. At the time of the incident, held a final warning, which was issued to him in 2019 for not taking the breathalyzer test each time when entering the company's premises at numerous instances, as per his own admittance. So here the employer actually says, well, the policy is you have to do it, and if you don't, so yeah. So I think maybe incorporate, especially where I would say where an employee is going to dispute the readings, you say, okay, do you agree we're going to take you then for a blood test? You could even probably incorporate it into your policy in terms of testing in any event. There's a case where I think I do have it in here with Samancor Chrome. It is here, where the employee also tested positive for alcohol using a breathalyzer test on an Alcoblow rapid machine. Thereafter, the employer utilized another machine, the Lion Alcometer, and again it indicated alcohol. However, a blood sample drawn from the employee and so analyzed by an empath laboratory indicated the opposite result. So yeah, it happens that we get false positives. So imagine if they hadn't done the blood test, the employee could have faced being dismissed at the end of the day.
Kim, I think also what is important here, and back to basics later on, I will also, just refer to this. We often refer to policies and so on, but I think also in this case where maybe the employee was on a final warning previously for same or similar, and then part of the final warning was that he should report every morning to be tested. Now on this particular day, he's dodging that test, without reporting to be
exactly.
So we mustn't forget the value of the required standard in written warnings or in discipline. I do see a lot of our members, my clients, who doesn't have that in their warnings, and they don't use our prescribed one. But I do see a lot of them where they fail to include the required standard. That required standard is so valuable, so valuable. Not only here, like in this case, but also in cases like you have to notify your immediate manager personally on the first day of absence. Those required standards, very crucial, guys, very crucial.
Yeah, definitely. So with this Samancor matter, they actually called the doctor from Empath, who he's a chemical pathologist, to actually come and give evidence. And he said that blood tests were obviously more accurate than a breathalyzer. And the breathalyzer test could be false in certain circumstances. For example, when the person has not eaten for more than 8 hours, that's quite interesting because it changes that's when you start going into with the whole keto thing. So that could definitely, as you see now what he's saying here, that it could have an effect. Or eaten any substance with a yeast content. In his opinion, the result of the test performed did not mean that the employee had not had any alcohol at all in his blood, but simply meant that there was no blood alcohol content exceeding 0.010. But for all clinical purposes, the result had been negative.
I wonder what would happen if he only drank water, Kim, had nothing to eat, but he only drank water. If that would if that would raise the levels or lower the levels. In my opinion, I'm not an expert, but I think that would raise the levels because he's reactivating that yeast, that fermentation process.
Possibly, yeah. Yeah.
Andre, your mic is off. Andre, you muted.
Johan, if I can just jump in here.
Thanks.
Please bear in mind, whiskey is not the same if you have water afterwards. You must do it properly the first time.
Yeah. Okay, so I've asked Johan to give me the courtesy of a break, and he's going to take on the situation of the PSA evidence and medical certificates. I think it's actually quite a good thing that we just understand when we're dealing with the evidence and the law of evidence. So yeah, thank you, Johan.
Yeah, thanks, Kim. Guys, it's so easy to do this when Kim has done all the homework, so I cannot take credit for any of the contents of this part. Thanks, Kim. So we're dealing here with hearsay evidence, and I think the question that we have to look at is from both sides, whether the evidence that we're introducing is coming from the respondent side or coming from the employee or the applicant side. Either way, the same test will apply. So Roseanne, earlier on when you asked the question, should the doctor be called to come and testify at the arbitration if it is a false, or will a letter be suffice? I think when we go through this, we will come to the same answer at the end of this part of the presentation this morning of the dialogue. So what we have here is, I think we first have to just establish and to say that there is the Law of Evidence Amendment Act of 45 of 1988, and in particular Section 3. So, and just to summarize, it establishes specific rules for admissibility, but we're going to discuss also, because remember, there's a different level of proof in terms of balance of probability, so that we must also consider. But let's just go through it step by step to say that the general rule is hearsay evidence is inadmissible. In other words, that as a general principle, it should not be allowed because of the following reasons. And then you'll see 3 reasons there. The person who made the original statement is not available for cross-examination. Well, we know that you cannot cross-examine a statement or a document. It raises the risk of inaccuracy, as the person conveying the statement may misinterpret or misreport the facts. So true, so true. I read something and I have a different interpretation. We also see that in case law, coming from judges, from very learned academics who have different interpretations. And then thirdly, it can prejudice the opposing party, denying them the opportunity to challenge the source of the statement. Very true that just to give you an idea here also, I have a problem when there's a legal representation application and the applicant party addresses prospects of success, because that is evidence now. And my feeling on that is, it's slightly off the topic, but still quite relevant, that there's now evidence in front of a commissioner who's considering an application, who will now have knowledge of the matter before we start with evidence. Just my view on that. So then in the Amendment Act, when the Act was amended, there were exceptions to inadmissibility, and the Act allows for hearsay evidence to be admitted under specific conditions. The decision to admit such evidence is left to the discretion of the court, based on whether it serves the interest of justice. Below are the key exceptions. Now, that discretion of the court there should be very bold, big font or so, because remember, in terms of the CCMA rules and that, there's a lot of leeway given for a commissioner to exercise discretion in matters. So, but let's look at these exceptions. By consent of the parties, if both parties to the proceedings agree to the admission of hearsay evidence, it can be accepted regardless of its nature. Plain straightforward. If the maker of the statement testifies, which means the person who wrote the letter later testifies during the proceedings and confirms the statement, the hearsay evidence becomes admissible. So if you have a document included, but you are going to call the doctor, then it is admissible evidence. I've also made a note here personally from my side also, and I am of the opinion that if it is not opposed, if it is not challenged, that letter from the doctor, then you do not have to call the doctor to come and testify to that letter. So I would say just add that part in. It's open for discussion, colleagues. Then admissibility in the interest of justice. The court may admit hearsay evidence if it serves the interest of justice, such as the nature of proceedings, civil or criminal, and now even in our case CCMA matters. The purpose of the hearsay evidence, whether it's necessary to prove key facts. So in support of, let's just look at this, in support of evidence where you're trying to prove a pattern or that type of, is it really key evidence? That's up to you to also interpret. The probative value of the evidence, how reliable it is, balance of probability, here we are. The reason the declarant is not testifying, such as death, illness, or unavailability, any prejudice that the admission may cause to the other party. So this is also very important. Just like to go back for a moment to the previous one, the reason the declarant is not testifying, death, illness, or unavailability. Remember, the unavailability is not simply just because I cannot accommodate because I have a business meeting. This is for more obvious reasons like being overseas or whatever. However, with online meetings today allowed, virtual, I think we're going to have a problem with that. But also I know deathbed declarations, deathbed statements carries a lot of weight. Also here, I also want to introduce that we can also consider recordings which has been transcribed, the value of that. In other words, during a disciplinary hearing, the recordings used there. So how do the application of hearsay rules in labour law? In labour law proceedings such as hearings at the CCMA or bargaining councils, the strict rules of hearsay may be relaxed. Commissioners often focus on ensuring fairness and efficiency in decision making, making hearsay admissible if it is considered reliable and relevant. And then there's a case law example for us, Woolworths Pty Limited versus CCMA and others, a 2024 case, a very recent case. Hearsay evidence was introduced about alleged fraudulent medical certificates. The Labour Appeal Court held that the employer's reliance on hearsay evidence about suspicions of fraud was insufficient without direct evidence, demonstrating the importance of balancing fairness with flexibility in such settings. You'll remember we had that discussion. So what is the impact of this improper hearsay evidence? Admitting hearsay evidence without meeting the exceptions can lead to injustice by denying the opposing party a challenge to challenge it. Courts may ensure that procedural fairness is not compromised. The improper reliance on hearsay evidence can result in the decision being overturned on appeal or review, especially where it has a material impact on the outcome of the case. So mitigating the impact of fraudulent medical certificates, verify certificates by contacting the issuing healthcare provider, review and update sick leave policies to include procedures for validating suspicious certificates, use monitoring systems to detect patterns of absenteeism linked to specific practitioners, educate employees on the consequences of submitting fraudulent certificates, and promote transparent attendance policies. Right, so these are guidelines that we've included here for you. But I'd also just like to go through one or two relevant case law authorities on this. There's a case, Littleton Dolomite Pty Limited versus NUM on behalf of Lekau and others, which was handed down in 2020. And this is quite important, that during the course of the arbitration, the employer's representative did not call any of the witnesses who had testified in the disciplinary inquiry, but had testified himself. So here we are. I'm an official. I'm not calling witnesses, and I'm giving evidence, but I'm not calling witnesses. The commissioner then excluded or disregarded the witness evidence on the basis that it constituted hearsay evidence, and drew a negative inference from the failure of the employer to call witnesses to the arbitration proceeding. However, this judgment said the commissioner had a duty to warn or advise the parties of the inferences, albeit negative, that she would draw, and that the evidence constituted hearsay evidence. The commissioner had a duty firstly to explain to the parties and to timeously rule on the admission of the hearsay evidence. Making a ruling on admissibility of such evidence only at the award stage speaks to the crucial aspects of fairness. The fact that the decision of the hearsay evidence occurred only at decision-making time is significant, as this prevented there being a full ventilation of the dispute and fair trial of the issues. So this is the judgment that I'm referring to there. The commissioner at the time should have raised this with that representative. So you're not calling witnesses, and I may draw a negative inference from that. Now, this judgment came also based on the Exaro Coal Pty Limited versus Chapana and others from 2019. And colleagues, please go and read this judgment. It's quite an important judgment, and it contains a commissioner's ruling on the admissibility of evidence. And there are 15 guidelines for commissioners on hearsay evidence in this judgment as well. So a very important judgment. And in short, what we are saying is you may have to call the medical practitioner to come and give evidence. And similarly, so if the applicant is not calling the medical practitioner, you may raise a point that it's hearsay evidence, and ask the commissioner, how will they deal with this evidence, because it is hearsay evidence. I think, in short, and as quick as I can without trying to exclude anything, I think that is as far as our knowledge of this matter is, but it's open for discussion. Thanks.
Okay. And then, of course, we have the one that is now had everybody abuzz, and we no sooner think it was a win for the employer. Look, whoever represented this lady was very clever, I must say, because they weren't just going to leave it at the fact of her dismissal being found fair. They decided to fight it further and further and further. So Enova was, it comes to emphasizing the need for employees to balance workplace safety, and it overturned the Labour Court's decision regarding the dismissal of Bernadette Enova, who tested positive for cannabis at work. It raised important issues around workplace policies, privacy, and cannabis use. She was employed as a category analyst and was dismissed after testing positive, even though she consumed it privately at home. Barloworld enforced a strict zero-tolerance policy for drugs and alcohol. She was dismissed for misconduct after admitting to the cannabis use, and the Labour Court initially found that her dismissal was fair, considering it a case of misconduct rather than unfair discrimination. However, on appeal, the Labour Appeal Court ruled in her favour, concluding that dismissal was unfair and discriminatory on arbitrary grounds. It highlighted that cannabis stays in the blood longer than alcohol, meaning that a positive test does not necessarily indicate impairment at the workplace. They also found that Barloworld's blanket application of its drug policy infringed on her right to privacy, referencing the precedent set in the Prince judgment, which decriminalized the private use of cannabis. With respect for employers employees' privacy rights. It also raised questions about the fairness of current drug testing policies, especially given the complexity surrounding cannabis detection and impairment and assessment. So when it comes to the test for unfair discrimination, you guys can make a note of this one is Harkson versus Lane. It's a 1998 Constitutional Court case. And this defines for you with regards to the test for unfair discrimination. Is it a listed ground? Is it a non-listed ground for differentiation? If it is a non-listed ground, what are the characteristics? Where does the impairment come from? And you'll see they actually deal with it quite a bit here. Also, there's another matter of, I will actually send these through as well, Marsland, and there's one for Janssen. Those are more recent cases, 2009 and 2018, also with regards to the test for unfair discrimination. So the court said here, okay, they argued that her dismissal constituted an unfair discrimination based on her spirituality, conscience, and belief. They interpreted her claim about the spiritual side akin to religion, which is a protected ground under the Employment Equity Act. But the court rejected this argument, noting that she never admitted her cannabis use was recreational. She had admitted that it was recreational rather than spiritual. So therefore, the dismissal was not directly tied to discrimination on a religious or spiritual ground. Like I say, whoever took her case on was thinking on their feet right from once those gates opened and the gun went off. They thought of every way out of this. Then they said, okay, but the policy discriminates arbitrarily because it fails to distinguish between alcohol and cannabis use. So while both substances trigger similar treatment, sending employees home when testing positive, alcohol users could typically return to work the next day, whereas testing negative with cannabis means that they'll test positive for days or weeks. The court acknowledged it, said that this is a disparity that could undermine cannabis users' dignity as an unfairly implied impairment without confirming their ability to perform their job duties performing at the time of the testing. So that's very important where, and yet we all know, I'm sure we've all had that gardener that comes in the morning, has his tea time, goes for lunch, has his little spiff there on the side, comes back, and he does the entire morning's work he does in that afternoon in an hour because he's working at, crazy levels. So it's to say, well, how do we now determine whether they can perform their duties at the time of testing? Because I know cannabis users that can perform normal, function normally without even realizing that they're under the influence of anything. So it is quite a difficult, I think it is quite a difficult thing to test, you know, it's to say, well, you've smoked, you have been smoking, you know, how intoxicated, how is it going to impact? Also referred to the privacy and discrimination. So they said with regards to the Prince matter, it decriminalized the private use of cannabis. The court found that the application of the employer's policy infringed on her right to privacy by penalizing behavior that occurred lawfully at home. It argued that the policy was overly rigid, disregarding the nuance of cannabis use and its lingering presence in the body without necessarily causing workplace impairment. The court also said that they acknowledged the legitimacy of workplace drug policies for safety purposes, but it found that Barlow's policy did not reasonably accommodate the difference between alcohol and cannabis use. As a result, the enforcement of the zero tolerance was deemed unfair and discriminatory, infringing on her right to dignity and privacy without justifiable causes. And I think it also comes down to now adjusting one's policy and procedure and disciplinary code in terms of saying, okay, so if you you'll see I've actually got a chart we'll get to just now, where it refers to sort of this high risk safety and sort of low risk safety in terms of your position. How are we going to treat it? So you might have to now adjust your disciplinary code that it doesn't say cannabis, testing positive cannabis dismissal, and now suddenly we're now doing finals and whatever, and they're going to come and say, oh, but we're being inconsistent. So I think we unfortunately going to have to make that distinction to say, yeah, low risk, high risk, office workers, factory workers, you're going to have a look how you're going to break up that distinction. So they spoke about the prolonged detection versus impairment. They recognize that cannabis metabolites can remain detectable in urine for days or weeks after consumption, well beyond the period of actual intoxication. Obviously, this raised the concerns. The lack of precision compared to blood tests. Blood tests which measure active THC are generally regarded as more accurate, as opposed to urine tests primarily just detect that it's there, which are non-psychoactive residues that accumulate in the body. As a result, a person may test positive in a urine test long after any intoxication has worn off. So it's going to come back down to the whole testing thing as well, unfortunately. We might have to maybe we should find a provider that's prepared to give discounted rates or something like that. Okay, so they said that the policy failed to account for these nuances. While urine testing might be a valid tool, it was not a suitable measure of real-time impairment. So the failure to distinguish between presence and impairment was considered irrational and discriminatory. The use of urine tests for dismissal in this context was also criticized for violating her right to privacy. They said that employers need to balance safety policies with respect to employees' dignity, especially when there is no immediate safety risk due to intoxication. That they underscored the need for more precise drug testing protocols, such as blood tests. So yeah, the court's saying incorporate it. So I think that whole thing, you see, as long as we can show the rationale or the link back to the workplace in terms of doing the medical testing, if we're scared of the Employment Equity Act side of things about medical testing and all of that. But here we're saying it is linked to safety protocols, it is linked to an inherent requirement of a job, for instance. We need to determine impairment, so we're including blood testing. So it sends a message that relying solely on urine tests to make employment decisions, especially in light of legal private cannabis use, can lead to unfair outcomes and discrimination. So for instance, if you're doing pre-employment testing, if you're only using a urine test, for instance, and you're going to get a positive on a drug test, could potentially become a problem in terms of the unfairness in terms of the testing. Here we have a situation again where with Samancor, the employee had 19 years of service. He was also dismissed for testing positive for alcohol during a breathalyzer test, despite later obtaining a negative blood test result. I think this one we spoke about just now, where he went to the laboratory and they actually said, but the laboratory came back, there was nothing, it was negative. The employer challenged in the award, arguing that the issue was a policy violation, not intoxication, and that the positive breathalyzer readings were sufficient grounds for dismissal. The court emphasized that breathalyzers can produce false positive results under certain circumstances, validating the CCMA's reasoning.
Sorry, can we just check? Conrad is asking, he's saying he's having technical issues. Anybody else with technical issues? No. Okay.
Okay. All right. So I've just given you guys a thing with regards to different scenarios with regards to cannabis testing. So we've determined it as safety sensitive designations. If you've got a reasonable suspicion of with regards to testing, post-incident testing, if you suspect that somebody's got a substance or is under the influence, and then there's scheduled rehabilitation testing. So if an employee refuses a test, we need to warn of the aggravated consequences, especially if it's a safety-sensitive designation. So perhaps that's the key word here when breaking it up between high risk and low risk is determining it as a safety-sensitive designation that the employee works in, where they're refusing the testing again with regards to the misconduct. Do your observation checklist of possible impairment, and then again you're going to look whether it's whether we're going to suspend and follow process, traces of cannabis, but no impairment indicators in a non-sensitive designation, monitor and obviously reserve the right to take action if it keeps happening. We obviously need to address this. Trace of cannabis with impairment indicators in a non-safety sensitive, suspend and follow due process. So it just gives you a bit of an idea, or you know, in terms of aligning your policies to something like this, when it comes to your cannabis testing, and then determining what is going to be high risk and low risk job functions as such. Okay, so this is the article that I spoke of. And it is in the bundle, so don't try and strain your eyes now to read it. But I'm just going to go through it briefly with you guys. So this just talks about the calibrations and concentrations and the misconceptions of breath alcohol testing in the workplace. And they talk about, this article focuses on breath alcohol testing in the workplace and the burden of proof and the balance of probabilities. And they talk about where there's a lower standard of proof, unfortunately established that acceptance alcohol testing results of lesser quality in labor courts compared to the approach in criminal courts. So obviously we base on a balance of probability. Criminal courts, we have to have, you know, there must be no doubt. So hence why you will generally be then taken for a blood test if you are found at a roadblock to be blowing positive. It deals with the addresses in the discussion revolves around the interpretation of the context of intoxication and under the influence. So that there's a difference between the two, the concepts of zero tolerance for inappropriate alcohol use in the workplace, the scientific correctness of lowering the breath alcohol threshold cutoff to zero, misappropriate misunderstanding of annual calibration certificates. So it's actually quite a nice article, this bit of reading material. Like I say, it's always good to equip yourself with all the tools. They talk about a medical scientific framework with regards to calibration certificates and why it's important. Because trust me, in an arbitration, especially if there's a union involved and you're going to rely on this as part of your evidence, they're going to ask to see that calibration certificate. So it needs to be calibrated once a year. And you'll be issued with a certificate to state that it has been calibrated each year. Let's see what else is here. They talk about so let's get here. So once again, they also talk about a testing protocol. Let's go to the next page quickly. Here they talk about a testing protocol with regards to, at the correct protocol is as follows, that you should test the subject and is observed for 20 to 30 minutes during which they are not to smoke or consume water, as Johan said earlier on, or eat anything to oral cavity contamination by with mouthwash, for instance. You know, we all know that trick. You've got a bottle of mouthwash in the cubbyhole in case the cops pull you over in a roadblock or you quickly light a cigarette. So all those things can obviously impact your actual breathalyzer. So this is where that 20 to 30 minute observation comes in. So they test positive, they blow green, wait that 20 to 30 minutes and retest again. They say an initial air blank test is performed, which must register a no alcohol response. The first breath test is performed, and then a second air blank test analysis, which must register a zero again. And then you do your second test and a third. So they talk about testing at least 3 times. And then your control specimen in the form of a certified alcohol dry, they call it dry gas reference, not too sure. So I've got on my checklist that impairment to check for the physical impairment. We've got another list, a document as well, which then you have a witness with you when they do the breathalyzers to give the different reading, the times that you've got a witness, that the employee is present, also signing what the readings are. Again, coming back to just, I know it's, which seems all we do is paperwork and policies and procedures, but at the end of the day, we know where the onus lies when we land up at an arbitration or at the labor court. That unfortunately it's going to lie with the employer at the end of the day. Okay, any discussion around that? Any questions?
Colleagues, I just want to point out, when you look at this article, and you look at the authors of this article, you would see that they basically have the same initials and the same surname. So, no, I think this is quite important. If we just look at that page where Kim was now there,
Okay.
credentials there, that the one is the legal practitioner and the other one is the director of forensic toxicologist. So it's not a father and son at the same law practice that wrote this article. I think it's important to realize that it's two total different occupations coming from two different or both opinions, the legal plus the forensic
toxicology.
Yes. I think that's important for us to know, because the first impression you get, oh yeah, well, it's a father and son in their practice.
Two attorneys writing about something. Yeah.
Yeah, so it's easy. I agree with my dad, type of thing.
Yeah.
Then also the next thing, Kim, you know, when you read all of this, you're getting the impression that we're moving closer to beyond reasonable doubt than balance of probability, when you're dealing with this particular subject. What I've taken from this, Kim, personally for myself, is that really we should have three policies. We should have one for alcohol, we should have one for cannabis, and then we should probably have one for other drugs. Because other drugs might not stay in the blood as long as cannabis, so you might have a different test. So I think we have to investigate all three of these possibilities and possible incidences. You know, what is interesting for me in all of this also is, from experience and so on, is prescription medication. You know, I think we can in the near future still expect something coming of that. You know?
I had an incident like at one of my clients, and the guy was he was taking, actually the doctor couldn't understand how he was actually still alive. That is how much over-the-counter pain meds this guy was taking. Yeah. He would go into meetings with my client had a meeting with the big importers for the North Star techies, and he was part of the meeting, and he came in and he sat down and he took his socks and his shoes off and he put his feet up on the desk. He doesn't recall going into the director's office. He was so zoned out. And then she's the type of employer, she's hands-on with everything. You can see she's got a law degree behind her. So she's a clever girl, and she started investigating this, and she consults with the doctors and the pharmacists and asked for all these receipts and things like that. And at the end of the day, we unfortunately landed up dismissing the guy because she kept saying to him, "Tell me you've got a problem so I can help you." And he kept denying it. Eventually she said to him, "You know what? Then I've reached out to you. You don't want to be honest about it. There's nothing more I can do for you." And it was not nice. He'd been with her for 15, 16 years of employment.
I thought we just put it out there, but I think also the crux of that, Kim, is if you look at the impairment in the workplace. That is the key principle here, the impairment, you know. And yes, it was. We had one in my office, Kim. I had one in my office that sat for 2 days with a hand on the mouse and not clicking once for 2 days. She sat there. She did nothing. We went. Ivan didn't check on the keystroke. You know, there was no key on the mouse. There was nothing for 2 days.
Sure.
Yeah.
Yeah, and that's the sad thing is that these opioids that are available over the counter are just as addictive as any other type of drug.
In our case, exactly what you said. Deny. No, nothing. Don't worry. I'm all right. Yeah.
Okay, so just touch a little bit on we all know the raids that have been happening, and then I know Suna did the slide, and then the Department of Labour came out with its 100 days, like most of the ministers did, and said, well, at 100 days, this is now, actually it's quite interesting what her surname is, but anyway. So our Minister of Labour, Madam Meth, has revealed that they conducted more than 17,000 inspections and have issued enforcement notices worth over 24 million rand. And this was within their first 100 days of her taking office in the Department of Labour. So you can see, and this obviously came partly as a result of the raids and the TikTok video, and that obviously opened up this whole can of worms. But there are specific industries that they are focusing on. So they did, you know, we only saw the little restaurant thing, and we thought it was just like a big sort of a reaction to the TikTok video and that lady's sort of plea that went out that this all happened. But if you look, there's been over 17,662 inspections done on a national basis. Of these, 12,195 workplaces were compliant, which is actually quite, I must say, quite impressive. I would have thought that the figures might have been the other way around. So only 5,494 workplaces were found to be non-compliant. But if you take that and you work that back into the 24 million, that is a scary figure. So obviously these inspections were conducted with the Department of Home Affairs, Department of Transport, South African Police Service, the Hawks, and the Bargaining Council of the Hospitality Sector, resulting in 81 arrests of employers as well as undocumented immigrants. They say the high impact inspections and compliance rates they're going to target hospitality, road freight, textile, car manufacturing, farming sectors, to the high and non-compliant sectors that they seem to be focusing on. Looking at the standard employment practices that render workers vulnerable, and I think especially in the farming industry, I think it's still very much a big thing. They address and ensure job preservation with the employees enjoying the protection of their rights. Obviously, we want to continue with economic growth, but obviously we don't want to be exploiting people. So I thought it's quite a good thing just that we educate our members as well, just in terms of what happens when that inspector arrives at the door. And number one is that the employer doesn't adopt an attitude, because I don't think it's very conducive in most instances. I've just learned that over the years, because these inspectors are pretty ruthless. So they are there to monitor and enforce compliance. So they may, without a warrant or notice, at any reasonable time. Okay, we're not talking about domestic employer places now. Reasonable time, enter any workplace or any other place where an employer carries on business or keeps employment records that is not a home. So you can see how many employers are going to be taking stuff home now. At any place at which any person provides or purports to provide any employment service, as defined in terms of the Employment Services Act. A labour inspector may enter a home with the consent of the owner or occupier if authorised to do so in terms of subsection 3. So that's a labour court authorisation. Employers are entitled to verify an inspector's status or powers in terms of section 63.3 and section 66.3. There's also, if you look at CA 13 in the basic conditions, there is a pro forma one for you to see, and it actually says to you, not every labour inspector can come in and say, I'm here to do employment equity and workplace occupational health and safety and compensation and this and that and UIF. They are given designated functions. So you're entitled to see that if they don't have that designation on their appointment certificate, you can actually then deny that what they're then requesting and say, but you're not appointed to inspect this information or to request it. They may require a person to disclose information either orally or in writing, and either alone or in the presence of a witness, or on any matter to which an employment law relates. Inspect and question a person about any record or document to which an employment law relates. Copy any record or document or remove these to make copies of, but if removing it, then the inspector must issue a receipt to the employer. So again, there's the BCA 10 and 11. So they cannot just leave the premises without It's the same as serving a warrant in a criminal case and all of those. They have to issue with a formal receipt of what we are removing. So make sure that if you're not there, that your members are aware of this and what their rights are in terms of documentation being removed, because the inspector now takes it and removes it, and we don't know what their systems are like once they get back to the office. And if this goes missing, what recourse have you then got? What proof do you have that it was removed? So, yeah, it's just one of those, I call it your CYAs, your cover your A processes. So just just an email to your members, just to give them a heads up, you know, what are their rights? What can they ask? What are they entitled to take if they do? That they must be issued a receipt that this stuff has been taken.
An interesting thing to say, to make copies, which means return it, please. You can take it, but return it. It's not, you can't keep it permanently. Eh? Yeah.
Correct. So with regards to the whole employment of the foreign national thing, Elisa had a discussion about it, and we know that, for instance, with some of you guys, we know that some of you operate in the function of actually standing in as an HR role. Some of you are sitting a day or two at an actual client in that role. We'd hate for one of you to be the ones that are going off with a beautiful set of silver bracelets because there might be the foreign national issue. So we thought about just dealing a little bit about that and saying, well, what we're suggesting is that employers should conduct an internal audit. So make sure this audit covers all aspects of labor legislation. What I've done is, it's quite a nice audit document that I have included in the bundle for you guys. It's quite extensive, so you can adjust it, you can amend it, but it covers everything from company registration documentation through to everything. You can add in things, take out things, but it's going to cover possibly everything and anything that any of the inspectors might come and ask for. So it's possibly good to do these and to actually have these, do it maybe every 6 months, or if you've got a lot of foreign nationals, maybe even do it more often, but that you can actually show when the department comes and say, well, you know what, we do regular audits. Here's our proof. So just to give you guys peace of mind that we're also on top of things. Also validate work permits, check expiry dates, position, type of work, mention of work visas, and versus the position and the work that the employee is employed in. That is very, very important. So if you have a guy that's on a specific work visa for a specific job function, let's say as a welder, and he's working as a driver, you're going to have a problem. That visa is not going to cover him. It's then going to, it cannot work like that. If you've got a driver and you're going to promote him into a welder, and you've now trained him up and he becomes a welder, you're going to have to go and get that visa amended. He cannot work outside of that scope of what is contained in that work visa. So that is very, very important. You need to make sure that your clients understand that. I've seen a lot of times where the guys, the visa says he can do this specifically, and he's doing a totally different function. Now we think we're in the clear because we've got a work visa, but where it's very specific positions or job or task orientated, it's not that easy. So verify the permits with the Department of Home Affairs or use a third-party service provider. If you're going to go directly through to Home Affairs, I've got verifications that I've been sitting with for over a year. It can take a few weeks and it can take months, but retain proof of those emails. So when you send the email out, make sure you've got your little boxes on there to have your receipt that it was delivered and that you have a read receipt that you can show them. Listen, here's proof that it was delivered. Here's proof that it was read by the Department of Home Affairs. So we've done as much as we can from the employer's side to verify these permits. A non-compliance with the Immigration Act can lead to the arrest of the responsible person, which is the employer and the employee in question. Now, I can tell you, unfortunately, it's not all members, but I'm sure there will be those that will say, but Johan, I've employed you as the responsible person. Jy's mos die kennis. You come and sit here twice a week and you're performing the HR functions. he's going to tell the SAPS, well, there's my responsible person. He's supposed to be on top of this. Yes, I'm the employer. Yes, I can be held liable, I suppose, but I don't think he's going to be going down alone. So yeah, if you are part of that function or part of that role, or that's part of your scope of duties with your client or your member, make sure that you are the one that's doing all of this to protect yourself at the end of the day. Also included for you, so on your asylum seekers, the guys that have gone to register with VH, that global company, if you click on this link up here, and I've tested it, it actually works. It's pretty good. Your employee would have brought you back quite a long, thin receipt back that they've registered with a tracking on it and a number and whatever. Click on the link and you fill in the tracking number, and actually gives you the information of who the applicant is, when they received it, where it is in terms of the process, and obviously it validates that it is a legitimate receipt that has been issued. Then giving you other information here, other areas where you can also then look at in terms of home affairs, in terms of also validating and requesting those validations to be done through them as well, but they are pretty slow. I've tried another third-party provider. I'm getting a response back within less than 24 hours. So it can be done. Obviously, I can imagine the influx of emails that these guys are getting. I just don't think they can possibly handle it, and probably lose sight and focus. They're probably sitting still on last year's emails that they must reply to. Okay, so to say in that bundle, I have included a audit document for you guys that you can utilize. I think it is quite a good tool, especially if you've got a new member and you don't know what you're letting yourself in for, or what they do and don't have in place. I think that's pretty good to have, that you can actually go back to him and say to him, okay, I've done an audit, and this is the areas of concern. This is where we need to be focusing attention immediately. This is what you don't have in place. This is what we need to get in place.
Sorry, it seems my chat was hanging here a bit, and I think there are some questions even relating to previous topics. So I have also posted in the group chat to say it's up and running now again, and that we will open up for any questions thus far if we missed anything. There are some questions there. The one from Rudolph is just the slides. Will they also be available for download?
Yes.
Okay. Rudolph, yes, it will be. And then Razan has asked the question. I think what we should do is let's open it up, Razan, if you want to ask live. Put your question so that you can explain the question nicely and so on. And if there is anybody else, please just raise your hand and we will give you an opportunity. Sorry about that, guys.
No worries. Are you asking me to ask the question now, or must I wait?
Yeah.
You can ask it now.
Okay, but I actually have two questions. Whereof the one is relating to the specifically alcohol, not just the cannabis use. Are we basically saying to each other that the alcohol offense now is going to, any dismissal will need to do a blood test? Or are we saying a breathalyzer accompanied by a visual observation would be suffice? That's the first question.
I would say I don't think. I think I would do a blood test, possibly where you have an employee that's arguing with you, that he's not going to accept it. But it's not a hard and fast. I think if you've done the visual observation, most commissions are accepting that together with your breathalyzer. You've done the breathalyzer, you've done the visual observation, so you've done as much as you can. You've done everything. Just out of interest, we've got a client where when the drivers get there, the guy at the gate that's doing the breathalyzers, he's been taking alcohol swabs, and he's wiping the area where they must blow with alcohol swabs. So when the driver blew on the breathalyzer, obviously it gave this positive. So they refused to give him entry, and he came back to my client, and we tested him immediately 3 times, and he was negative. Then he told us, but this is what they're doing. So that's why it's so important to have that, it's not just say, you're positive, you're going to go to a hearing, there's so many influencing factors that happens out there that one has to take into account. But yeah, I would say definitely, I think that the observation document is really, really important. I know a lot of employers can't afford the breathalyzers. So yeah, it's the observation document. If you've got a good extensive one that goes through everything, I think that's definitely a golden tool to have.
My concern with that is, Kim, because you said now that if the employee is disputing it, okay, so let's say he's not disputing it, and then obviously the weekend he goes to the tavern and he speaks to all the attorneys in the tavern, and in arbitration, all of a sudden he disputes the legitimacy of it. Then basically, my sense is you're going to end up in a position where they can start quoting all this case law that you've brought forward to say, but the company did not. My worry is, where are we going to end up with this?
But
Sorry,
that's
Kim,
exactly what I said earlier on about the case that Hubin had as well, is that the guys that sit and determine these outcomes are not down there on the ground with the employer facing these scenarios every single day. And if you've got 100 employees and 5 are going to test every day positive, you must be paying for 5 blood tests every day. Where's that going to leave you in terms of your finances?
Yeah, no, it's
Kim,
insane.
Sorry, Rizan, I just want to add on to what Kim said. But before I do that, Kim, what you've just said now is so true, because somebody on the group this week also commented to say these lawyers are so clever until it's his wife or their child in the car with a driver that's intoxicated.
Exactly.
Then it's a total different situation,
Yeah.
Don, what I want to add to this, I don't think the blood test is that important. Because even if you send this person for a blood test and his blood level is 0.5050, that doesn't mean he's impaired to do his job. Because you and I have different capabilities and different levels of impairment. So even the fact that there's blood alcohol present in my system doesn't mean I'm impaired. Because I can handle more than you or less than you understand? So the more important test here, guys, would be the sobriety test.
Yeah.
Comes in when you do random testing on a Monday morning, for instance, and 5 of your employees test positive, but there are no other symptoms. So that's the problem that we're facing with here, to say, what now? And then it is advisable to rather go and do a blood test. Just as and Tim said a very important thing, your whole checklist in determining whether the employee is under the influence or not. Yes, that's a sobriety test or whatever you want to call it, but also a breathalyzer test. That forms part of it. I've had it where a commissioner asked me, but why didn't you perform a breathalyzer? Why not? These things you can buy at the chemist. Why not perform that? You've only done a sobriety test, so you don't know if it was a stroke with permission. You don't know. So it is on a balance of probability, all those things result.
Yeah, and I think definitely, and I think also definitely, Razan, in your policy when it comes to the testing, you should definitely have that interval and do the 3 tests. I think that's also pretty important. Don't just let your members rely on the first test and that's that. Definitely say to the guys, okay, guys, we're going to test you 3 times. You sit here, you go nowhere. You don't smoke, you don't eat, you don't drink. Yeah. You sit and you wait, and we're going to test you 3 times.
No, I agree with that.
Yeah.
I would like to go back, unless Dirk is commenting on this, I would like to go back to the portion that you dealt with, Johan, in terms of still my doctor issue, but maybe, I don't know if Dirk is on this topic or whether he's on a...
Go ahead first, Rizan.
Sorry, repeat
Yes,
that?
I would like.
Go ahead with your question, Rizan.
Okay, so sorry, Dirk, age before beauty. the question is as follows. As employers, and dit is nou maar net hoe my brein werk, we are required to accept the signature of the doctor because they are governed by the Health Professional Council on a doctor's no, okay, maybe just give me a chance to just get the proper wording here. I seem to recall that a doctor's signature carries more weight than just a general person. So we as employers accept when our employees bring us 6 notes that it is true and correct because it's been issued by a doctor. Let's say there is no fraudulent action involved with it. If we had to call in on every arbitration, the doctor specifically, you take professionals who is in the emergency services out of their day-to-day responsibility. So my question is, due to the, I almost want to say, for lack of better words, the seniority or the professional capacity of a doctor, does it absolutely, do you still need to call these guys in for an arbitration? Why? Can you try? I'm really struggling to pose this question, but I'm hoping that you can read between the lines.
Jy wil antwoord. Johan, jy kan maar praat.
Just one thing, there's not a lot of weight or more weight to be put on a doctor's signature. So remember, it is exactly the same for both sides. So if a doctor issues a medical certificate, that is hearsay evidence until the doctor is there to testify about that medical certificate. So if we have a reason to believe that that is not a valid or whatever we want to use this for, in your pre-arb minute or wherever you can say that that document is in dispute, that we do not believe that that document is what it purports to be. Therefore, Kim, if I'm correct, then the applicant must then call the doctor to be witness, not us.
Yeah, it's employees.
Sorry, I understand your question from the other side, Razan, that if we say it's a false doctor's note, do we then have to bring in the doctor to give evidence? Yes, except if there are clear discrepancies, as in the case that Kim mentioned, where the addresses differ, the telephone numbers differ, the practice differ, all of that. And we even, my clients take a Google map, a Google Earth, Google Earth photograph of that address, and there's no doctor's rooms there, you know, that type of thing. So it works both ways, Razan, if that answered your question.
Maybe I can just add, thank you for that, Johan. Maybe I can just add something. So let's say you've sent through to either the hospital or the clinic or the doctor to verify the legitimacy, and they've responded back in writing and confirmed that the doctor's note or the sister's note was not issued by them. If you add that to the mix,
I think that's sufficient.
My view is if that letter from the doctor is not disputed, there's enough weight on that. If it is disputed by the employee, by the applicant, yes, we will have to call a witness.
Okay.
Can you add to this? I see you've put yourself online.
Yes, I just can you hear me? I don't see. Can you hear me now? I just have an issue with the blood test. Remember, if the guy is under the influence of liquor, can he really consent to an invasive blood test? My view is that he's not capable of giving permission. We cannot force him to do a blood test. Just my view.
Thank you on that. And in this particular case about the hearsay evidence and the doctors, anything you want to add on that, Ramda?
Well, yet again, you know, if we dispute, there is a principle in law that he who alleges must prove. Now, if the applicant comes and he alleges that this is a medical certificate, claiming that he was incapable of working, he carries the duty to prove that that is true. If he brings a doctor's note and we don't accept that, he will still have to call that doctor to come and say, this man was indeed incapable of performing his duties. He is making the allegation, not us.
Thank you, Mr. Rizal. Anything else from your side on this topic?
Nee, dankie baie.
Andre,
So, Jan, can I just add on there? I think also, Razan, was actually quite important that if you've got an email back like that to say, we confirm that this is not from us, blah, 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 it's imperative, I think, that the employer already in the disciplinary hearing, even though your arbitration is hearing de novo, but in the disciplinary hearing, say to the employee, this is the evidence that we have. Do you dispute this? Because I think there and then you could possibly even do a conference call that the employee can see, that you do a conference call to the doctor's rooms, for instance, to even confirm that this email is from them and the content thereof. I think that would also add a little bit of weight to it as well. Just something very quickly, just to point something out to you guys quickly. They say, if a patient requests an extension of the original sick leave that's been allocated, the practitioner should insist on conducting a follow-up consultation and should issue an additional medical certificate. They say they may not extend the initial period of sick leave and issue an additional medical certificate without having consulted with and physically examined the patient. So that's I think that's quite just to put in the back of your mind that where the guys, we have the thing of the booked off for, we're supposed to come to a hearing and we're continuously sending in sick notes and things like that. Make sure that it's not just a situation of, I have been informed that the patient is still ill. There is very, very clear guidelines that they should actually physically be consulting with that patient again if they're going to keep extending the sick leave.
sorry, Kim, where were you reading from?
It is in the health professional, in the ethical rules of conduct, in terms of rule 16.1.
Yeah, colleagues, just take note of that, where that came from. It wasn't specifically case law or anything like that. Andre, are you still with us? Your question?
Yes, I am. Thank you, Johan. I just want to reiterate the fact. We must understand with regards to labor relations, common sense must prevail. And I think Dirk touched on this as well, you know. And remember as well, if a matter ends up at a CCMA, it's a balance of probabilities. It's a totally different, how can I say, manner of proof that you need to submit. One mustn't get lost in all the technicalities of different case studies. Common sense on the day with specific to the incident needs to apply. That would only be my 5 cents worth.
Andre, yes, thank you. You know, I think we all agree with that. I think our next session on Saturday, we can invite the commissioners to this discussion to also understand common sense.
Very common sense as well.
We agree with that. Absolutely, but I think that's important. If I can just go back to some comments on Kim's last topic that you had, the immigration compliance and so on. Just one tip also that we do, if there is a work permit that would expire, let's say in 6 months' time, we give a fixed project contract for the duration of that permit. In other words, the contract will also expire in 6 months' time. So that also or helps you and assists you not to have to go through a whole procedure when that contract expires. It still applies. If it's longer for 2 years, you have to pay the severance pay. Remember also that we're waiting for amendment, which may increase the severance pay amount. We believe, the rumors are, that it will increase that. So just that as well. And then I don't know who of you attended the family meeting with President Ramaphosa last night about these tuck shops and shops. They are going to have a blitz on these spaza shops, and that they must be registered and then they must pass a health test. Guys, what I read from that is who are going to do those blitzes. I think we can relax for a while. We're not going to have problems over Christmas with inspectors attending to companies doing these inspections. It's a total assumption, but I think we can relax for a while. They'll be busy with those inspections, you know, the spaza shops and that. Just the way I see that, correct?
Yeah, there are only 2,000 inspectors, but apparently Minister Meth has said she would like to increase them to 20,000. So yeah, that's her intention.
Any further questions, or can we move on to back to basics? Thank you, Kim. I think we can move on with
Okay.
the slides and that.
Once again, don't try and strain your eyes on this. It was a document that I had that I came across when I was busy preparing for this, and I thought it's actually quite nice because it's a nice little, I think it's a 3-pager, if I'm not mistaken. It was a 2-pager, and it's really briefly just got the pertinent rules, the application, the number of days. So it really outlines a lot of stuff instead of you having to run through your book the whole time. I think this is pretty handy just as a to have with you. That hunt all the time without having to page through the big pieces of legislation to go and look for all this stuff. So Jan's going to do just touch again on the back to basics. There are sometimes questions about this with regards to time periods and all of that. So just let's do a bit of a refresher on it.
Yeah. So colleagues, first of all, what happened was I had a recent case. Well, let me start at the beginning. What we see often on the Q&A group, everybody asking for case law about certain topics and that. And most of these we can address through CCMA rules. We don't necessarily have to go to case law. It's clear. Those are the basics. These are the CCMA rules. And Dirk also said earlier on, Andre said, common sense prevails. So the first thing is I want to ask all colleagues, when there's a training session with new rules, these type of training sessions, please go and attend those. I can't tell you how many times that I've taken out this booklet where the commissioner says, you see, he attended the training. He knows what he's talking about because you can see he attended the training. And it already carries a lot of weight when you take out this booklet. And it's concise, it's nicely explained. There are documents in the back, your performer documents, etc., etc. So it is nice to have, and we know the rules. We know it's going to change. Just go and attend it and get the book. And then if you don't want to sit for the rest of the 2 hours listening to trade unions, just make an excuse, but get the book. In any case, so what in fact happened where I motivated to Elise and to Kim to say, let's talk about back to basics again. What happened was there was an application for legal representation, which the applicant filed, and they never addressed complexity of the matter. So they only based their application on 3 other levels. Then we responded to that within the 5-day time limit, which is what the rule says. Then the applicant party never replied to our response within 3 days. Then the rules never responded. So on the day at the CCMA, the applicant said they would like to respond to our opposition. And I brought a point in limine to say, Commissioner, you can't hear that. That's outside of time. And there's no application for condonation or anything like that. The ship has sailed, in fact. The ship has sailed. And the Commissioner agreed with me. He said, rules are rules. The CCMA rules are there for a reason. And the ship has sailed. Sorry, I can only base this decision on your initial application and not on your replying affidavit to the opposition. And that sparked this whole thing for me again of, let's just look at the basics. So you will see there that Kim has mentioned Rule 3, Rule 10, Rule 11. I'm just going to briefly go through them just to make sure that we understand. Rule 3, how to calculate time periods in these rules. Remember, days are calendar days, not working days. The words on, and then please also, in particular, again for this year, remember that the words on a day between 16 December and 7 January, that is being removed from the rules. So we cannot subtract those days anymore. Why am I saying this? Be careful with con-ops being scheduled during the festive season, during this period. Be careful of unobjectionable con-ops, Section 73, capital A. remember that you will have to attend to those. Please enlighten your members also about this, that they must still communicate all that correspondence with you. Also, just like to mention that, remember, when we're calculating days, the last day is included, and the first day is, or the day that you've received it, is excluded. So it starts counting on the following day, except if the last day falls on a Saturday, Sunday, or public holiday. Then it will be the first working day following the Sunday or public holiday. Colleagues, I don't ever play with the rules. If it is on a Monday, or if it's a Saturday or Sunday, I always make sure that I submit my document the Friday, the day prior to. Even though it gives us a shorter time, I don't like to play with it. So just remember, these rules, the time periods are very important. The document that Kim has referred to previously also explains the time periods to you as far as that is concerned. Then under Rule 10, it says how to refer dispute for conciliation. We all know 30 days from the date of dismissal. So once again, technical. When I get a referral form, that's the first thing I do. Check date of dismissal, date of referral. And remember, date of referral, that it was served on the other party as well as the CCMA. Rule 11, when must the Commission notify parties of conciliation or facilitation? I think we had a question this week as well. Can they wait a year before they schedule? Yes, there's nothing in the rules that prevents that, but they must give at least 14 days for notice for reconciliation. Then despite the above, the CCMA may give the parties a shorter notice period if the parties have agreed or reasonable circumstances require a shorter period. So your con-op, they only have to give 14 days notice, not 21 as in with arbitrations. So just take note of that, that in that case then your arbitration, if you have not objected, will commence immediately after the conciliation, which is then only a 14-day notice. Rule 17, that's the one we just discussed in terms of con-op. So if you have not objected 7 days before the scheduled date. However, here I would like to also mention that there is case law regarding the con-op objection, and that is Valinor trading as King's Castle versus CCMA, where there was a judgment to say that the fact that the objection was not done in terms of the rules, it does not detract from the fact that a party has objected. Just take note of that so that you can use that. What we do if we receive a con-op out of time, which means not 7 days before, we file the con-op objection. We mention in the con-op objection that we received this late for some whatever reason, and therefore it is not possible to object to the con-op within the specified time limits. It's not a formal application or just a mention on record. We could not, in terms of the CCMA rules, object timeless. We've even done this where we received a notice for a con-op over the weekend, and the matter was, let's say, 11 o'clock on a Monday. First thing Monday morning, we sent this con-op objection together with this reason, and by the time we went to CCMA, the Commissioner then accepted our con-op objection. Rule 18, how to request arbitration. You have 90 days, remember, not calendar day, not working days, but calendar days. And it must be after the certificate of non-resolution was issued. Just take note of that. So sometimes the matter is scheduled for conciliation. We agree to an extension of that period, the 30-day period. The certificate is then issued some 30 days later. Remember, then it's from the time of the certificate that was issued. When must the CCMA notify parties of an arbitration? At least 21 days prior to the hearing date. So for conciliation, 14 days, for arbitration, 21 days. How to bring an application, and this was the one, Rule 31, that I used in objecting to the attorney replying on the day of the arbitration. Rule 31 is 14 days before the hearing, the other party has 5 days to respond, and the applicant party has 3 days to reply to those. Just also rules, not only time, but where a conciliation or arbitration will take place. In other words, no jurisdiction application because it is brought in the wrong venue, center, or CCMA office. Rule 24 says the dispute must be conciliated or arbitrated in the region where the dispute arose or where the employer's principal place of business is located, unless a senior commissioner in the head office of the CCMA decides otherwise. The commission or commissioner within the region determines the venue for the hearing, which may include an online hearing. Verbatim from the rules. Just here also, we know the recent case, the Malawi case, and then I think there was one from Mozambique as well, where there was a ruling to say that the CCMA does not have jurisdiction because that person did not work in South Africa at that employee. Then Rule 35 deals with condonation for failure to comply with rules and forms, that the CCMA may condone any failure as a result of a degree of the lateness of the matter, the degree of lateness, the reason for lateness, why you believe that you have a good case, how the lateness may prejudice the other party, and any other relevant factors. Colleagues, all I'm saying here, is that we often want to move back to case law, where there are a couple of things. Check the dates. Check whether the trade union involved or who wants to represent, check their scope. Check the legal representation, was that within time frames? Section 73, remember also prescription clauses, 3 years. How long back was this claim dating to? The step down notices, have that been issued within the guidelines? And those are all very, very important questions that you have to ask in terms of CCMA rules and back to the basics. That's it. Thank you.
Okay, on.
Questions? Nothing? Anybody? Questions? Rebecca, Razan, Andre, Elise, Conrad, Renee, Ivan? Thank you. How's Andre?
I'm here, guys.
Yes.
I just need to say perfect. It's such a brilliant presentation by you and Kim that there's nothing that I can improve. So by all means, compliments.
Thank you.
Dankie. Okay, Elise, ek dink ons Dirk sou eers na een ingelog het, maar ons is omtrent klaar, so ek gaan maar vinnig net deur sy dingetjie hardloop. I said to him that I would do it if it was a situation where he wouldn't be back on time or be able to log in on time. This case is included in your bundle, but it's a matter of Satawu on behalf of Singh versus Copperset Sunset Trading. And the applicant was charged with dishonesty and negligence for not issuing tickets to passengers after collecting fares, resulting in a 24 Rand cash shortage. Despite being found not guilty by the disciplinary chairperson, the respondent reversed this decision and dismissed him. The respondent argued the chairperson's not guilty finding was inappropriate, inconsistent with company rules and past outcomes. The director substituted the chairperson's recommendation with a dismissal, citing the applicant's history of similar offences and a valid final written warning. The respondent presented evidence through 4 witnesses, including inspectors who confirmed the applicant collected the fares without issuing tickets. And they were found to be credible versus the applicant's evidence, which was found to be less credible. The Commissioner referenced legal precedents, including the Sidumu case, and the Rhodes M versus Rhodes University to justify the employer's right to review and alter the disciplinary chairperson's decision if it was unduly lenient or inappropriate. So the commissioner concluded that the dismissal was procedurally substantively fair, citing the applicant's repeated offences, lack of remorse, and the break of the trust relationship. So the application for reinstatement was denied and the dismissal was upheld. So it's quite interesting here, two things. I think it's just how little the shortage was in terms of 24 Rand. But the thing is, he'd been warned previously on a few occasions. And then obviously, I think the keynote here to take away is the fact that the directors were not happy with the chairperson's initial recommendation, and obviously then decided to override that and go with the penalty of dismissal. But case is in the bundle, so yeah, I think it also makes for another one that will be makes it interesting reading and good to hold on to. En dan is ons vroeër klaar wat ons sou gewees het. Dankie Lies. Ek sien Rosanne wou iets bygegooi het vandag.
Rosanne? Ja, Elise, voor jy vir almal baie sê, is daar ek wil graag die geleentheid gebruik as terwyl al die slim mense hier om my is, om net 'n teorie te toets. O, groet jy, Johan? Okay, so ek het so tydjie terug, kan ek maar Afrikaans praat?
Ja.
Ek het so tydjie terug het ek op die Q&A groep iets gepost. Ek kan nie presies onthou op hierdie moment nie, en daar's toe 'n paar van die officials wat dit was oor sick leave, gaan ons die roete van incapacity, maar is iemand wat net so onder die radar die heeltyd inkom. Die persoon maak seker dat hy laat weet, en dan bring hy 2 dae later bring hy sy siek sertifikaat, en die unpaid leave is nog nie opgebruik nie, die siekverlof is amper opgebruik, maar die realiteit is dat die persoon die operation so ontwrig deur sy absenteeism dat dit 'n totaal untenable situasie geraak het vir die werkgewer. Toe is daar van die officials wat my privaat gekontak het. Ek dink hulle was half te skrikkerig om hierdie ding in die groep in te gooi, met 'n totale nuwe benadering of 'n ander benadering tot die saak. En ek moet sê, toe ek die benadering hoor, het ek bietjie hartpalpitasies gekry, en ek het ek is effe bekommerd of dit enigstens uitvoerbaar kan wees of nie. So, die argument is as volg. 'n persoon wat binne in sy siekverlof entitlement bly, onder die unpaid leave entitlement bly, en binne sy leave entitlement bly, ontwrig nog steeds die werksplek. So die benadering kan wees dat die persoon retrench kan word, omdat die definisie van retrenchment spesifiek sê, dis operational requirements, ek wil hom gou net voor my oop kry, laat ek nou nie hier soos 'n imbesiel klink nie. Geef my net 'n sekond. Okay, so ons weet is by no fault of the employee, en dan sê hulle, or any similar, it's operational requirement, technological development, or any circumstances that might be operational. En die argument van die official is basically om te sê, die persoon hoef nie noodwendig die grasie gegee te word om sy volledige 30 dae oor 3 jaar op te gebruik nie. Alhoewel hy die entitlement het tot 30 dae oor 3 jaar. As dit jou operasioneel so negatief affekteer dat jy nie kan 100% produktief funksioneer nie, kan jy actually 'n retrenchment proses initiate met die persoon en vir hom sê, okay, ek wil nie hê jy moet verder siek wees nie. Blykbaar het hierdie official al suksesvol arbitrasies gewen, maar ek het nog nie die arbitrasie awards gesien nie. So ek het gedink, kom ek gooi dit hierdie benadering in die mix in en hoor wat dit julle te sê daaroor.
Rosanne, are you not able to show a pattern of abuse of sick leave, even though they're within their entitlement? There could still be a situation of abuse of sick leave, which is obviously then more a misconduct thing.
Because the employee keeps on advising the employer of his absenteeism, and it is not always sick leave. It would be an instance of his child is ill and he doesn't have somebody to look after his child. And it's random days. So it's the pattern. I could not establish a clear pattern because of the randomness of the days.
I've done in the past. I've actually what I've done now with the client. We had the same thing with the guy. Was forever family responsibility of child sick. Then it's the wife sick. Then it's this, and eventually my client said, you know what, he's done with this. I mean, even though he's taking it as unpaid, it's not the objective because you don't have the guy at work. I actually sent him drafted him a cautioning letter to say that we now monitoring it. Yes, it's going to be unpaid going forward, but if this continues, we will then obviously consider it that he's obviously abusing the rights that has been afforded to him. I don't know where I would go. Incapacity. Remember, incapacity is not just sick leave. So incapacity could also be the fact that he's not able to perform his duties because he's never at work.
I've got all this. I've got all that, but it was mind-blowing to actually have this conversation because if it is my legal right to take 30 days, but if I take 30 days, I put the company in a position where I disrupt their operations to such a degree that they cannot function. And I was like gobsmacked, I must be honest, and I'm very tempted to test this, but I don't want to like test it and then...
Please do let us know.
Here you are, Neeman.
I would also like to know this because bearing in mind, for me, operational requirements is based on the business and the restructuring of the business based on financial situations. And then again, if you retrench, you cannot re-employ for a period of at least 2 years. So for me, it would make no sense. It's my 5 cents worth, not worth, but not
I agree with
really.
that, Andre. I agree with that. But my view on that is exactly, I think, along the line what Kim has said. So what we do is when we start picking up this pattern, and specifically maybe under sick or whatever the case. So first of all, we sit down with the employee and we have a summary. Family responsibility leave, sick leave, annual leave, unpaid leave, absence, all of that. And then we say, look, here's a problem with your attendance. Secondly, as far as the sick leave is concerned, we give 2 letters to the employee. One to the employee giving an instruction to go to the doctor, and secondly, a letter to the doctor to say, please give us not a diagnosis, but a prognosis. So the difference is not what is wrong with this person, but how long will it affect this person, etc., etc. So the doctors are reluctant to give a letter to say, no, this person is healthy, you know, or is not healthy to work, because then we're going the route of medical incapacity. Now, if the doctor has said that this person is fit to work, why do you keep on being sick? Remember also, we have the right as employers to insist on a second opinion. So next time that you claim that you are sick, report here to the company. We will take you to our doctor. Don't just send a letter. Don't just phone in to say I'm sick. Report here. We will take you to our doctor. We're concerned about your health. We need to make sure that you are sick and that you get the right treatment, because obviously you are doing is not getting the right treatment. So
exactly.
So those are just a couple of things that we do also. I think, you know, and I will not, I hope the recording is off already, but sometimes we are creative in what we do and trying to, I first had to check quickly if it wasn't a private discussion between you and me, because that sounds like something that I will take.
So you're the guilty one.
we are creative in some of these things that we do, but we've also got to be, you know, I think Andre said that common sense will prevail. No, I won't go that route.
Yeah, I must say,
if
I'm
I can put in,
because there's a, I'm actually, sorry.
I would advise you not to go the retrenchment route. certainly not get a CCLA award
Yeah.
that says, oh, you were fine. I can tell you that you will be nailed. That is not the way to go. And another thing, I know my is very unstable, but one other thing is I've never heard of an entitlement a quota of unpaid leave. That is not for the employee to take. The employer is entitled to grant in unpaid leave in specific circumstances. He hasn't got an entitlement to specific number of days per annum of unpaid leave. My view.
I hear what you're saying, Dirk. My apologies. In the specific context, the employer has got a limitation in his policies to say that you are entitled in specific circumstances to a maximum of 5 days unpaid leave per annum.
Okay.
While we're discussing this also, I think we've just got to look at sick leave. And my interpretation of this is it says you do not need a doctor's certificate of that. Or it says you are entitled to be paid for leave after a certain amount of days if you submit. But it doesn't say that sick leave from the first day without a doctor's note is not disciplinable.
Yes.
It talks about payment of the sick leave. It doesn't say you are entitled to sick leave, full stop.
Yes.
So from my interpretation, that is why I would take that employee on there to say, wait a minute, there's a problem here.
Yeah, comparing to the rest of the staff in terms of their sick leave, you know, have something that you compare to say, well, you're taking 15 days and everybody else, you know, there's an average of 3 days. So, you know, or maybe there's a problem at home. We never know. So, yeah, there's lots of things to establish. I think, yeah, maybe it's good to have a sit down with the employee and do a good cautioning and actually put it in writing.
And I also believe, Ruzan, bearing in mind, you know, the Act is specific, the basic conditions. It clearly makes provision for 30 days sick leave. You as an employer cannot decide on, let's say, sick leave 10, that you're going to now retrench in converted commas this employee. You know, you have the right. It has to happen with the prerogative of the employer. But by all means, operational requirements also would not make any sense.
Ek hoor wat jy sê, Andre. Ek het finally nou die stuk gekry. So dit was onder die fokus van nie noodwendig ekonomiese nie tegnologiese nie, ook nie struktureel nie, maar similar needs of an employer onder daai kategorie.
Ruzan, ek het 'n advokaat gehad wat my dieselfde advies gegee het oor daai gedeelte, oor 'n advokaat, en ek stem ook nie saam met dit nie. Ek dink wie dit gesom Andre die beste. You cannot re-employ for a period of so long after that, whatever. Nee, jy gaan 'n probleem hê, hoor.
Nee, ek is bly ek het met julle hieroor gepraat. Soos ek gesê het voor ek die vraag genoem het, ek het hartpalpitasies gekry toe dit die eerste keer as 'n alternatief voorgestel was. Maar ja, dankie vir julle insig.
Ek dink daar's 'n rede hoekom dit vir jou in die privaatheid.
I was just going to say the same thing.
We're all labor consultants, guys.
Yeah, yeah. Okay, Yella.
But what I would like to say, Kim and Johan, doesn't matter how many people attended here. I think what you've brought to our table is of utmost importance, and you did it brilliantly. So thank you for that. To all the people that attended this session, yes, I'm glad you did. It's unfortunate. It makes me think in the sense of, am I taking the right direction in the sense of getting people together with case law dialogues? I'll have a discussion with you guys afterwards and see, should we do it, shouldn't we? Is the time wrong? Whatever the case may be. So, but Kim, Johan, everybody who attended, thank you so much.